This content rounds out our discussion about permit applications with some material about permit conditions and also about the quirks to do with strata titles. Here's what we're going to cover in terms of permit conditions. Firstly, when you can place conditions on a permit and some big no-nos in terms of what not to do. That conditions need to be clear and unambiguous, cannot apply to land outside the application, cannot be dependent on another approval such as TasWater or EPA, and need to identify the scope, timeframe and responsibility. We'll briefly touch on referenced conditions and on conditions that might require secondary consent, like the EPA and Environmental Management Plan, advice on other approvals, and the Section 53 of LUPA about granting and taking effect of a permit and how that all works in terms of timelines. Okay, so council or the tribunal make a decision and issue a permit. So what they need to be careful about is that permit conditions don't constitute a change to the nature of the development to such an extent that it ends up being a technical refusal. So in the example that I've got here, council would need to refuse a development if they didn't want a 3-storey house to go ahead with the 3rd storey. So you couldn't in this case issue a permit application that meant that the applicant had to remove the top storey of this house for whatever reason. They would need to knock the application back and the applicant would then be free to decide what to do, whether they took council's feedback into account and submitted a fresh application for a 2-storey house. So if council or RUMPAT's decision is such that it does refuse the development, there needs to be really clear reasons rather for the refusal. And the conditions themselves on any permit application need to be reasonable and they need to relate to planning matters. So occasionally councils do put conditions on that perhaps less than ideal because they're in a hurry or they get it caught up in some kind of internal discussion and an engineer wants some sort of permit condition. The planner isn't all that happy about it, but it goes ahead anyway. And 9 times out of 10, that's fine and nobody appeals. But this is what the manual is about, is counselling you to be really careful about making those decisions and making them in a conscious way, because they're the kind of decisions that get taken to appeal. One of the limits on conditions is that it can't apply to land outside the application. So the point of this photo is not the pair of black Labradors, but the gorse on the fence line here. So you can't have, for example, biodiversity conditions on a nearby block, which could be extremely frustrating. So part of the opportunity for environmental improvement when somebody puts in a development application is to survey for threatened species and to control weeds, particularly anything that's a WONS, weeds of national significance, so listed species that are known problems. You can ask the developer to get rid of those weeds. Obviously, this is pretty problematic if on the other side of the fence on somebody else's property, the weeds continue. And for something like gorse, it has huge potential to get back onto the property. But it's not possible for council to slap any kind of order for the developer to take care of weeds on the neighbouring property, because that would overstep the permit conditions. In thinking about land outside the application, the road reserve is interesting. So here's our house again, our 3-storey marvel. And so that's sitting adjacent to the council land, which has the verge, which happens to have some remnant vegetation in this case. And then there's the carriageway, which may be controlled by the local council too, or if it's a big arterial road, it might be controlled by Department of State Growth as the state government road. So in this case, then the land in the permit condition, the actual application might be for works that's in the road reserve, whether this is something to do with maintaining remnant vegetation or some sort of landscaping, something that's helping to offset the impact of the development in some way. So the road reserve includes the trees and nature strips, the actual road itself. And there's a lot of potential here for the development to impinge on that public space. So if we have a look at the Wynyard Street South Hobart example, you'll see that their application actually includes the adjacent road reserve because they're doing public footpaths and altering the traffic circulation because they're proposing to bring a lot more people into this relatively small street in South Hobart. And so as part of the application that is paid for by the developer, this work in the road reserve is going on. So that all can be part of the permit conditions because it's part of the permit application. So I hope that's clear. One of the other limits on permit conditions is that they can't be dependent on another approval. So you can't have a permit condition, for example, that requires the EPA's approval. So what you might have, what councils do sometimes as a courtesy more than anything, is that as part of the letter that lets you know about the permit and gives you conditions, they might advise you that you need to get a permit for the threatened species for whatever biodiversity values are on your land, but it's not actually part of the conditions. And so threatened species advice is separate and not part of the condition. So in the example of this gorse here, that would be quite separate and would be dealt with separately to the permit conditions. So the final thing about limits on conditions is that the scope, timeframe and responsibility need to be identified, and this all needs to be really clear. So you can't afford to be waffly in your conditions. Here's an example from the Wynyard Street development in South Hobart. So it's engineering condition number 4 that says that the driveway approved by this permit must be constructed to a sealed standard and drained prior to the first occupation. If the developer wanted to play hardball on this, sealed, air quotes, could mean all sorts of things. So the engineering department council that came up with this probably had a fairly clear idea of what sealed meant. That was probably to bituminise the surface, but it's actually not clear. So if that's what they wanted, they should have said that. So as well as being specific about that kind of thing, if you want things done by a certain date, like you want, for example, some sort of natural values survey done before commencement, then you'll need to say so. Otherwise, you could rock up to the site and say, you know, have you had your survey done? I see commence building. No, because we intend doing it in 5-10 years, but not now, and our permit conditions don't specify when that needs to be done. So you might need to say prior to commencement of works, prior to occupancy, prior to some date, and then it's clear. So again, it's thinking a little bit in a legalistic sense, and I know this is hard because to get it right and to be really clear in the wording takes time and takes space. So, you know, you could easily end up with a letter that has conditions that run to pages and pages that are clear and specify all the various wobbly bits that people could misinterpret, but that takes a lot of time for the planner to do. So sometimes it's just not practical, even though it might be desirable. Okay, we've talked through the need to put conditions on a permit that are reasonable, that conditions need to be clear, apply to just the title of the permit application, they can't be dependent on another approval, they need to be precisely worded as much as people can manage in terms of the scope and the time frame. So now just to cover reference conditions, conditions requiring a secondary consent, advice on other approvals, and finally section 53 of LUPA. So this is what a reference condition might look like. So TAS water is really commonly required for subdivisions. So if you put in a permit application for a subdivision, you'll need a reference condition that's part of the permit. But in this case, TAS water, EPA, whoever the other body is, will issue a separate set of conditions that are referenced as part of the permit. So they all form part of the conditions, but they're a series of documents. So TAS Water doesn't plonk all of its requirements under the council specifications for their permit conditions. It's an attachment. So you can see this is quite a formal notice for the planning at 47 Benvenue Road, St Leonard's, for a subdivision of 32 lots. So this is setting out exactly what conditions are required on for TAS water for that particular permit condition. What is a strata title? In Tasmania, it falls under the Strata Titles Act of 1998, and it refers to a form of ownership that was devised for multi-level apartment blocks, like you see on the right here, but also applies to regular horizontal subdivisions that have shared areas, where there needs to be an arrangement and a set of rules around the shared areas, whether they're shared access or some other common area. The strata comes from the original application to apartments being on different levels, so strata being different titles. And yeah, it was introduced to Australia to better cope with the legal ownership of apartment blocks, so that you had clear ownership and clear mortgages and clear rules about how the body corporate forms. So you've got quite separate rights of occupation. So you've got those quite powerful title rights that aren't just about living there. And yeah, they might include common property, but they also might not. So if, for example, you've got a house on a corner block, you might be sharing services like the water pipe, but you not necessarily have any common property because you might have your own driveways and your own frontages. But normally it doesn't include some common property as well. So although strata title kind of makes sense on paper, in practice it's really difficult because people get involved, and you're probably all aware of the terrible arguments that body corporate gets into, because yeah, you've got often quite a large number of people involved who have to try to get along. And sometimes the body corporate bylaws, which the body corporate makes themselves, has nothing to do with council, they're supposed to be quite formal, meetings minutes, formal records, but this rarely happens, and so it can be a bit chaotic and yeah, quite difficult. So they're quite a different form of land division to the one that we've been talking about so far, and it's really just a means of dividing up property within a title so that you can have really clear ownership over the common property. So if it's, for example, a road, and you also have, for example, common insurance and a means of setting up the rules around that. So if somebody that's visiting you and that gets into trouble and needs to sue, then there's a process for dealing with that, other than everybody getting into a big fight. So not everybody loves this Strata Titles Act in Tasmania. There's an argument for it being dealt with under LUPA and just extending LUPA to deal with strata titles. Anyway, that's not the decision that was made, and it does come under a different act. So just to reiterate that point, that a lot is different under the Strata Titles Act compared to what we've been talking about so far. The lot means that part of the site allocated for separate occupation by the owner or whoever has the right of occupation. And the lot means the parcel of land with respect to which there's only one title. So if you are applying for development on your strata title, then it just applies to your lot. So you can't, for example, try to occupy your whole lot and say, well, look, the whole larger title is this size and I'm only occupying a certain amount of that title, even though my lot is smaller, I'm taking up my whole lot. Council won't buy that. That's not the intention here. There still needs to be consideration of open space, and that same mechanism works as well. So strata title is considered as part of the normal planning approval, and you only get approval for a strata scheme if you've satisfied the requirements of the rest of the planning scheme under LUPA, and that if it involves building work, that certificates for all the relevant buildings have been issued. So you doing this, you might be coming up with a strata scheme for an existing building, but if you're doing this as part of a development application, then you don't get that certificate of approval until you've actually got tick off on both the planning and the building. The middle section here, stage development scheme, is something that is often encountered in larger subdivisions where a developer might want to sell off some of the earlier developments. So they might come up with a master plan for developing the land in, say, 4 stages, with the intention of selling off stages 1 and 2 perhaps before stages 3 and 4 are built. So this might be a means of managing the business so that the developer can keep their income stream going. So under a normal subdivision that doesn't have a stage development, you might be building all 24 units all at once, for example, like in Wynyard Street, South Hobart. But in the case of some of the bigger subdivisions like Glebe Hill over on the Eastern Shore, then it's normally done as a stage development. So this is improved in principle, and you can have permit conditions that specifically refer to this. So it might not refer to time, so you might not have permit conditions around time. There might be, but normally it would be up to the developer as to how long it takes, because it's essentially a business decision. The third thing on this slide is about community development schemes. So this could be a marina, a retirement home, and you can attach things to the strata. So if, for example, your community development is on a golf club and there's strata titles as part of that, you might have requirement that a golf club membership be part of buying into the development. So it might seem a bit weird, but this is where the whole self-selection thing comes in. You wouldn't buy one of these locations if you weren't actually keen on golf and wanting to become a member. So yeah, the master plan must include 2 or more of the strata scheme. It must be a sealed plan, and it can be approved in principle and subject to conditions like everything else. Okay, I hope that has helped. I know it is a little bit tricky in terms of asking a question in these fora, but that's what Milo discussion is for, so please do get in contact if you've got any questions.